alaikum and welcome to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia and I'll be with you for the next hour. As our regular viewers are aware, the free legal advice show provides you, our viewers, the opportunity to call in and ask us any questions that you have on any aspect of English law. On this show, I should be able to cover a vast diverse range of matters ranging from immigration law matters, family law matters, criminal law matters. So whatever your legal questions are, please do feel free to get in touch on the numbers that appear at the bottom of the screen. Two ways to get in touch. You can call us on the landline number which appears at the bottom of the screen and you'll be able to speak to me live here in the studio. Secondly, another very popular way of getting in touch is to send us a message on the mobile number which also appears at the bottom of the screen. You can send us a message on that mobile number. That message will be fed through to me here live in the studios and I'll be able to look at your question and advise you in relation to your queries live on air. So to speak to me live on air, please ring on the landline number which appears at the bottom of the screen, and the mobile number is there for text messages, WhatsApp messages with your queries. A very popular way of getting in touch. So please do continue to send your questions in either on the landline or on that mobile number which is there at the bottom there. A couple of minor points before we get going. On a live show, sometimes it's not possible to take very detailed information from callers who call in. Sometimes it transpires that the matter is quite complex and I need detailed information from you before I can advise you properly. Sometimes it transpires that I need to look at your documents before I can advise you properly. Now, if your matter is complex or I need to look at your documents, then I'll ask you to leave your number with the control room and I will give you a ring off air and I can have that more thorough discussion with you after I've managed to have a detailed conversation with you or I've managed to look at your documents. But the vast majority of questions that we get live on air, I am able to address them live on air as you're speaking to us. So two ways to get in touch: landline number to speak to me live and that mobile number there to send me a message which I'll be able to see here live in the studio. Now, as always, we've had a number of questions coming in, and the first question that's come in is quite a popular question even in practice, and which is to do with delay. And the question that's come in relates to a brother who submitted a spouse application for his wife, and he's received a message basically stating that the processing of the application has been delayed. So brother says, Assalamu alaikum, I've made an application for my wife to join me in the United Kingdom. I have now received a message from the Home Office saying that because of the Ukrainian crisis, my wife's application, the processing of my wife's application has been delayed. What should I do? Now, actually, this is a very, very common situation at the moment. In practice, we are finding that numerous applicants who applied, say about 2 months ago, 3 months ago, have started receiving this particular type of email. And the email says that, thank you for your application. Unfortunately, the processing of your application has been delayed. The reason for that is that we have staff now dealing with the visa issues which have arisen from the Ukrainian crisis. A lot of the staff have been deployed from their normal teams to the team that's dealing with Ukrainian visas, and therefore there will be a slight delay in the processing of your application, and the email then advises you not to get in touch. Now, the question is, can you do anything? But the reality is, unless your case is absolutely exceptional, there isn't really anything that you can do. Clearly, they have looked at your case. They've acknowledged that your application is in process, and they've come back to you and said, you know what, we can't progress it much further, or there is a delay in progressing this case because staff have been redeployed to other teams. So in one sense, you can be rest assured that they have your case and it's not been lost in the system anywhere. It is there. Now, obviously, you would want your application to be decided as quickly as possible. That's understandable. But it does look like all the cases which are in the system at the moment, especially spouse applications, mainly those people who are applying from abroad to come to the UK, a lot of those applications in terms of processing of the application has been delayed. What can you do? The reality is you can't really do anything. Now, if it's the case that there are absolutely exceptional circumstances, there's a really compelling reason as to why this particular application that you've submitted needs to be considered, not in the normal way that they consider. You need to be able to jump the queue, have your application considered more quickly. There must be exceptional circumstances before the lawyer or your MP can really write to the Home Office and try and persuade them to, allow your case to be considered first and for a decision to be issued in your case. Now, general delay, that we've been apart for a while, or maybe somebody is suffering from slight illness, nothing significant. None of that is going to work. The normal problems which arise from being apart for a long time, maybe if you've got minor illnesses, none of that's going to work in terms of trying to get the Home Office to allow you to jump the queue effectively and give you a decision quickly. None of that's going to work. Really, in the vast majority of cases, I would say in 99% of cases, if you've received that kind of email from the Home Office saying, look, the processing of your application has been delayed, the reality is you're going to have to wait. There isn't much you can do on that. So that's very unfortunate, but as I say, in practice, we are getting, clients are contacting us more or less every other day, say, look, screenshot of the message, saying, look, this is the email that I've received. What can you do? There isn't anything that can be done. Really, you have to wait until you get the decision in the normal way. Now, how long a case is going to be delayed for because they've redeployed staff to the team that's dealing with Ukrainian visas, how long is the delay going to be? Well, they've not said. They've not said the processing of your application has been delayed by a couple of weeks, couple of months. So who knows? But making a rough sort of a guess, rough estimate, I would say it might take around an additional 1 or 2 months for your application to be processed. So applications were coming back prior to this particular problem. Applications for spouse applications were being processed and decisions were coming back in approximately 3 to 4 months. I would say we're now more around the 5-month mark in terms of spouse applications being processed. So it is unfortunate, but all I would say is just have a bit of patience. You're not the only person in this particular situation. It will get resolved. If you waited 3 months, really it's just a question of waiting another 2 months or so. My personal view is that the processing time is probably moved from around 3 to 4 months to around the 5-month mark. I hope that answers your question. As always, to speak to us live on air, please ring on the landline number which appears at the bottom of the screen, and the mobile number, you can send us a message on that. We've had a number of questions coming in, so let's look at the next question that's come in. And it looks like another immigration question from Brother Walid. Let me read the question out and then let's see what is the solution to this. Brother Walid says as follows. Assalamu alaikum. I have indefinite leave to remain for 1 year under the EU settlement scheme, as I was married to an EEA family member, an EEA national. I was planning a few months ago to prepare to apply for citizenship, but I heard it would be refused if I overstayed in the United Kingdom. It's been 7 years since I first was granted a residence card in the United Kingdom. I have heard that the law has changed and I could apply for citizenship, or I could switch to the 10-year route or the 5-year route. Please help me. It's very important. Now, what our brother Walid is saying is that he has indefinite leave to remain under the EU settlement scheme. So you can't really switch to another visa category now. You don't need to switch to another visa category now because you already have indefinite leave to remain. The problem is, as you've correctly identified, that if you've overstayed in the last 10 years, that will mean that the Home Office will conclude that you're of bad character because you've overstayed in the last 10 years, and your application for citizenship is likely to be refused. Now, I appreciate that for the last 7 years, you've had a clean record because you would have gone into the European visa, which then ultimately has led to you getting settled status. But the problem is they will look at the last 10 years, and if there's been overstaying in the last 10 years, it could cause a problem. Now, I will look at this in greater detail because there is some more I need to say on this. We're taking a short break. Inshallah, we'll be back in the next couple of minutes. See you then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on it, you could ring on the landline number which appears at the bottom of the screen. And as always, popular way of getting in touch is to send us a message on the mobile number which also appears at the bottom of the screen. So to speak to us live, it's a landline number, and to send us a message, a text message, a WhatsApp message, you can do that on the mobile number which appears there at the bottom of the screen. Now, just before the break, I was looking at the question relating to Brother Walid, who wants to apply for British citizenship, and the question is that he has indefinite leave to remain in the United Kingdom under the EU settlement scheme, wants to apply for citizenship. The problem is that there has been a period of overstaying in the last 10 years. To me, from the question, it looks like the period of overstaying was approximately 7, 8, 9 years ago, around that time. And then after that, you got married and managed to get into the EU visa system. And ultimately, after spending 5, 6 years under that scheme, you've got indefinite leave to remain. Now, the problem is that now that you have got indefinite leave to remain, you don't switch your visa route. The next step simply is to apply for citizenship. And as I said before the break, the Home Office is actually quite strict in terms of looking at the last 10 years. And the way they look at it is to look at it from the date you make the application. They go back 10 years. And if you've got any period of overstaying, I think they might disregard, the 14 days where you might have just applied slightly late for your application, or your application got refused and then you managed to resubmit the application within 14 or 28 days. So I think they'll disregard that. But the general overstaying that you have, where somebody overstays for 6 months, a year, and then somehow manages to get back into a visa route, which then ultimately leads to indefinite leave to remain. That kind of overstaying, in my experience, is not ignored by the Home Office at all. So I've dealt with cases where people have overstayed. So they've applied, and if you look at the 10-year history, their overstaying has been approximately 9.5 years ago. So really towards the very end of the 10-year period that they look at, a couple of months in the 10-year period, they've overstayed and then managed to sort their visa out after that. So they might have had 9.5 years of absolutely lawful residence, but there's few months, 6 months or so, where they were overstays in the United Kingdom. They managed to then regularize their stay in the United Kingdom. Now, even that period of overstaying, a short period in a full 10-year period, even that short period of overstaying is used against the applicant, and if the nationality application is refused. I mean, I personally can't see how that can be explained away. The way they look at it is that, look, if you were an overstayer, you were an overstayer. They're not going to look at why you became an overstayer, what happened. They won't have any sympathy with your particular situation. My experience is that they do take a very straightforward black and white approach to it. You either were an overstayer or you weren't. And if you were, they will refuse the application. Now, if you try and challenge that, you pay the fee that you need to pay and you try and challenge that, even then the Home Office will simply turn around and say, look, we, based on the evidence that we have on our system, we were allowed to make the decision that we've made. They don't have to agree with any points that you make as to why you overstayed. So you might have certain circumstances, where, it wasn't your fault, whatever, but they won't look at that. The only scenario in which I can see you might be able to argue that period of overstaying should be disregarded is if the period of overstaying was whilst you were a child, and really you can't be held responsible for that because you would have had parents who were dealing with your situation then in terms of any applications, etc. I think that's the only situation that I can think of where there's been a prolonged period of overstaying which should be disregarded. And I'm not sure whether there's anything specific in the rules or not, but I can see a valid argument there as to why that should be disregarded. But generally speaking, an adult who makes an application for citizenship, if that adult has overstayed, then unfortunately that will mean that the application for nationality will ultimately be refused. I can't see a way around that scenario. So practically, what do you do in that situation? Well, what you then do is you wait for 10 years of clear lawful residence before you apply. So you've said in the message that you've sent me that 7 years ago you managed to obtain legal residence in the United Kingdom. So you go back to the date you obtained legal residence in the United Kingdom. So for example, if it was 2014, let's say for example June 2014, that's the time, that's the date on which you get your visa to stay in the United Kingdom after a period of overstaying. So what you then do is simply count 10 years from that date. So if it's June 2014, when you first obtain legal residence after that break, then you count 10 years from that date. That would take you to June 2024. You would make your application then. Let's say you want to take a risk and you want to apply. Fine, let's say you make the application. If your application is refused, then the risk is, and this will inevitably happen, is whatever fee you've paid will be retained by the Home Office. They will refund to you, I think it's £80, which is the fee that they take for the citizenship. That is what's refunded to you. The fee that you've paid for the application, other than the £80, the fee that you pay to have your fingerprints biometrics enrolled, that would be lost as well. So you're looking at losing around approximately £1,400 if you were to make this application without a clean 10-year history. Now, brother did also mention that whether you should come out of this route and go into a 10-year route or a 5-year route. I can't understand why you would want to do that because that's not going to make a difference. It doesn't matter whether you get your indefinite leave to remain under EU law or whether you've got your indefinite leave to remain under normal immigration rules. Once you apply for citizenship, both types of permanent stay in the United Kingdom, both types of indefinite leave to remain applicants are considered in the same way. Your residence over the last 10 years is considered in the same way. It doesn't matter how you obtain your indefinite leave to remain. When you make an application for nationality, you go back 10 years. It doesn't matter whether you got your indefinite leave under the immigration rules or whether you got it under the EU rules. Hope that answers your question. Now, as always, to speak to me live on air, please ring on the landline number which appears at the bottom of the screen. And as always, to continue to send us messages, you can do so on that mobile number which is also there at the bottom of the screen. Okay, let's go to our next question. Another immigration law question, again relating to nationality. And this is to do with when you can apply for nationality. Assalamu alaikum, brother. I have now obtained indefinite leave to remain in the United Kingdom. Please can you advise in terms of when I can apply for nationality? Can I apply straight away, or do I need to wait before I apply for nationality? Please clarify this issue. Okay. It's a common question that comes up in practice, which is, when can you apply for nationality? Now, the rules for children are different. The rules for adults are different as well. Here we are dealing with an adult who wants to apply for British nationality. And the question that's been asked is that once you get indefinite leave to remain, when can you potentially apply for British nationality? Is there a time period that you need to wait, or can you apply straight away? Now, even in practice, this is something that comes up quite regularly. When can you apply? Because if you think about it, people who are here in the United Kingdom with a visa, they might have extended their visa a couple of times. Now they've managed to obtain indefinite leave to remain. Once you've got that, your next step is to get nationality. When can you get nationality? Well, the simple answer is this: that if you're married to a British national, you can apply straight away as long as the other requirements are met. If you're not married to a British national, then as a minimum, you're going to have to wait 1 year before you apply for British nationality. So the question in terms of when you can apply is really determined whether your spouse is a British national or not. If your spouse is a British national, you can apply for citizenship straight away. If your spouse is not British, might have another nationality, then you have to wait a minimum of 1 year before you can apply for British nationality. So that's really the earliest that you can apply. There are obviously other requirements that need to be fulfilled in addition to that. This is only looking at the earliest period that you can apply. But there are other requirements which need to be fulfilled. For example, there are requirements relating to good character. And we had a question that came in specifically on that you need to have been of good character for 10 years. There are requirements in relation to criminal convictions specifically. If you've committed a criminal offence, depending on your sentence, there are certain time periods that you would need to wait before you would be able to apply for British nationality. Likewise, there are specific rules relating to absences from the United Kingdom. If you've been absent from the United Kingdom for a certain period of time, you will not be able to apply for British nationality. And lastly, one of the other main things that you need to look at when you apply for nationality is the English language requirement. If for any reason you obtained indefinite leave to remain and you didn't have to pass the English test, when you apply for nationality, you will need both the English speaking and listening test at B1 level, and you will need to pass the Life in the UK test as well, unless you did it for indefinite leave to remain. So there are a whole host of requirements which need to be fulfilled, and I hope that clarifies the issue that you have. We're taking a short break. Inshallah, we'll be back in the next couple of minutes. See you then. Assalamu alaikum and welcome back to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia. To speak to me live on air, you can ring on the landline number which appears at the bottom of the screen. And as always, a very popular way of getting in touch is to send us a message on the mobile number which also appears at the bottom of the screen. So to speak to me live here in the studio, please ring on the landline number. And in terms of sending us a text message or a WhatsApp message, you can do that by sending that message on the mobile number, which is also there at the bottom of the screen. Always popular method to get in touch is the messages that come through on the mobile number. Let's have a look at the next question that's come in. We've had a number of questions on nationality law. This is slightly different, and this question again relates to immigration law, and this relates to when you can apply to extend your visa in the United Kingdom. Let me read the question out, and then let's have a look at what the answer to that is. Our brother says, Assalamu alaikum, brother. My wife is here on a spouse visa. Her visa expires in July 2022. This is the first extension. When can I apply for an extension on her behalf? Okay. Again, in practice, it's a very common question, and not just about spouse visas, but it applies to different kinds of visas as well. Question is, when can you apply? Some people think you should apply 3 months before. Some people think you have to apply 28 days before. If you leave it, you become an overstayer. Some people think, oh, if you apply too late and you don't get your decision by your visa expiry date, you become an overstayer. Now, the reality is, if you look at it this way, that the latest time that you can apply is the day that your visa expires. That's the last day on which you can submit your application. I certainly wouldn't recommend that you leave it that late. You should really be looking at this and preparing this much, much earlier. But anyway, let's look at what the latest and the earliest date is. So ideally, you'd apply in advance, but in terms of the absolute last day on which you can apply without there being any problems is the day on which your visa expires. If you apply even 1 day late, you're potentially an overstayer, and there could be complications which arise as a result of that. Now, okay, that's the last day on which you can apply for a visa. What's the earliest? Generally speaking, with most visas, you should apply within the 28-day period before your visa expires. So apply within that 28-day period, not prior to that. However, this brother circumstances is such that wife's visa finishes in July 2022. Now, if you do want to apply early, you can actually apply earlier. And what I would recommend is that if you want to get the application in much earlier, look at the date your wife actually came in to the United Kingdom. The date will be in her passport. On the visa sticker, they normally stamp the visa sticker with the entry date. So when she flies into Heathrow, into Manchester, wherever she flies in, her visa would be stamped. So that's the entry date in the United Kingdom. Now, my view is, if you really want to apply early, what you can do is count 2.5 years from the date she entered the United Kingdom, and she can potentially apply for an extension 2.5 years after that date. Now, that could be much earlier than your visa expiry date. The reason for that is this, that when you're granted a visa from your home country, you're actually granted a 2 years and 9 month visa. So it's not a 2.5 year visa, it's actually 2 years and 9 months. So if somebody travels straight away to the UK, their visa card will be expiring not after 2.5 years. The visa card is going to be expiring 2 years and 9 months down the line. So if you don't want to wait until your visa expiry date, you can count 2.5 years from when you got the visa and apply for the extension at that stage. So that's really the earliest you could apply. Now, if you're applying for indefinite leave to remain, the situation is slightly different. Again, you can apply on the last day that your visa expires. So If you've been on a spouse visa, you've been here 5.5 years, your visa card is expiring, yep, you can apply on the last day of your visa. You can absolutely do that. There's no problem with that. But if you want to apply earlier, all you do is you look at the residence requirements for that particular route. So if you take our very popular route, which is the spouse visa route, where somebody has been in the UK for more than 5 years. So in our example, if somebody's been here for 5.5 years, the spouse visa route only states that you need to have lived in the UK for 5 years in total. So the moment your 5 years are going to come up, once you've done 4 years and 11 months, potentially you're eligible to apply for your indefinite leave to remain, because you look at each particular route. Now, if that route has a requirement that you need to have lived under that visa for 5 years, once you're about to complete that, you're eligible to apply for that particular visa, which is indefinite leave in this example that we're looking at. So you don't have to necessarily wait until the end of the visa that you currently have. That's really the last date you can apply. There are circumstances in which you can apply much earlier. Now, what I would advise is, if you are looking at applying earlier, that the rules are slightly complex, I would look at, I would consider getting some advice from a solicitor. You can then do the application yourself later on. But if you speak to an immigration solicitor, they should be able to advise you on what's the earliest date that you can potentially apply for a visa, for your extension or for your indefinite leave to remain. But thank you very much for that question that you've sent in. So as always, to speak to us live on air, please ring on the landline number which appears at the bottom of the screen. Alternatively, as always, you can send us a message on the mobile number which is also there at the bottom of the screen. Okay. Let's look at the next question that's coming. Again, an immigration law question. Let me just read the question out. Question is this: I have lawfully lived in the United Kingdom for 30 months. So that's 2.5 years on the 10-year route to settlement. I have an 11-year-old daughter. I also live with my husband. We have passed the English and financial, passed the English requirement, or met the English requirement. We've met the financial requirement as well. What's the best option in terms of applying for an extension? So somebody who's here under the 10-year route to settlement, to me it looks like both the wife and the husband, both of them are here on the 10-year route to settlement. They have a child who is 11 years old in the United Kingdom. I suspect they've got their residence in the United Kingdom based on the child. The 10-year route is normally, in this particular situation, based on children who are either British or children who have lived in the UK for 7 years, and it's not reasonable to remove them from the United Kingdom. Because of the child's circumstances, the parents are given a visa under this 10-year route to settlement. Now, a lot of people understandably are not happy about having to wait 10 years before getting indefinite leave to remain. And you get a lot of questions in practice about clients who want to change their visa from the 10-year route to a 5-year route. How do we quicken the process to indefinite leave to remain? Is there a way of shortcutting it? How do you get to indefinite leave much earlier? So it's a very, very common question, whether you can get out of this 10-year route, go back into a 5-year route, get your indefinite leave much more earlier, or do you have to wait for 10 years before you get indefinite leave to remain under the 10-year route? Now, if you really do need to look at the circumstances. In my experience, there's two different types of circumstances. One is like the scenario that we have here, where both parents were previously overstayers. So neither has indefinite leave to remain, neither has a British passport. So they are both on the 10-year route. And fair enough, they've got a child and they've got their visa based on the child, but both of them are on the 10-year route. So previously, the vast majority of cases, both of them would have overstayed. In that situation, it's really not possible to leave, generally speaking, it's not possible to leave the 10-year route and then go into the 5-year route. That's only possible, the switch from the 10-year into the 5-year route. It's only really possible where one of the partners is British or has indefinite leave to remain in the United Kingdom. And the reason it's possible is that it's possible to move from the 5-year route into a normal spouse visa 5-year category. So it's possible in that situation where one of them is British or has indefinite leave to remain. The other situation where it might be possible is where you're somebody with contact rights and you're not living with your partner, but you're having contact with your partner, in that contact with the child. In that situation, in certain circumstances, it's possible to move into the 5-year route to settlement when you get to the extension stage. So, but the problem is this: even when you move into the 5-year route, the problem is you still have to complete another 5 years before you get indefinite leave to remain. So it's not just a question of moving into the 5-year route, counting your previous residence to make up the 5 years. That's not the case. Once you move into the 5-year route, you do start from year 0 again, and you build up your 5 years before you get indefinite leave to remain. So in a lot of cases, in my experience, there's no real advantage in moving into the 5-year route because your finances might not be right. You might not have managed to pass the English test. Most people then just prefer to stay in the visa route that they're in already and don't really bother trying to switch routes. Hope that answers that question. It's an issue that's coming up quite regularly in practice, people wanting to switch from 10 years into 5 years. Taking a short break. Inshallah, we'll be back in the next couple of minutes. See you then. Assalamu alaikum and welcome back to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. And as always, a very popular way of getting in touch is to send us a message on the mobile number which is also there at the bottom of the screen. So to speak to me live on air, you can ring on the landline number, and to speak to me or by text or send us a message, you can do that on that mobile number, which is also there at the bottom of the screen. Okay, had another question that's coming in, interesting question. It really relates to a recent change in the immigration rules. Now, let me read the question out. Brother says, Assalamu alaikum. I applied for my 4th leave to remain in November 2021. 2 kids born in the UK. We are still waiting for the biometrics. Okay, I'm not sure about that. I think your biometric enrollment should have taken place. I think what you're waiting for is your biometric card. I do apologize. So you submitted your application in November 2021, and I think from what you're saying, you're waiting for the application to be processed. Okay, now you've got 2 children born in the United Kingdom. Now you say, my question is, the new statement for children leave to remain in the UK, in relation to that, somebody who's been in the UK for 7 years, can they apply for indefinite leave to remain? My son is going to be 8 in August, inshallah. Okay, I understand your question. I understand exactly where you're coming from. That there has been a change in the immigration rules. Initially, the way the Home Office dealt with it is to say in December 2021 that we are introducing certain concessions. So not a change to the immigration rules, certain concessions were introduced. Now, as I understand it, those concessions a couple of weeks ago were then incorporated into the immigration rules. So now, instead of just having concessions outside the immigration rules, you now have specific immigration rules dealing with this scenario that you are talking about. And it's specifically about children. What it does is children who have overstayed in the United Kingdom, it shortens the time that they need to obtain indefinite leave to remain. So previously the position was the typical scenario: mum and dad overstay, the children overstay with them. So they've come from abroad, whether on a visit visa or whatever it is, they've overstayed. Many years have gone by, and because the children have lived in the UK for a long period of time, they've been granted leave to remain, not indefinite leave, they've been granted a visa to stay in the UK. Now, because they've been granted a visa to stay in the UK, the question is, when can the children, get indefinite leave to remain? There's two ways of looking at it. One is, if the children were born in the UK, then when they reach the age of 10, it doesn't matter that they overstayed in the UK. When they reach the age of 10, they are able to apply for British citizenship. So there's a process called registration for children. So they are able to apply for British citizenship. So children born in the UK can apply for British citizenship after living in the UK for 10 years. Now, if you have a situation where the child wasn't born in the United Kingdom, then they can't apply for citizenship based on their own circumstances. You'd have to wait for one of the parents to apply for citizenship, which obviously, if they're all overstays, that's not going to happen anytime soon. But what they can do is apply for indefinite leave earlier than their parents, but that only applies in certain circumstances. Now, if you look at the actual rule, the new rule that's been introduced, which we didn't have before, what it says is this: that if you are now over the age of 18, you've lived in the UK legally for 5 years under this 10-year route that they have, and you have lived in the UK half your life, then you can apply for indefinite leave to remain now, as opposed to completing 10 years in the United Kingdom under the route that you're under. So there's a couple of requirements that need to be fulfilled. The child must have now turned 18. The child must have had valid leave for 5 years under this human rights category. And the child must have spent half their life in the United Kingdom. If those conditions are fulfilled, then it's possible to apply for indefinite leave to remain in the United Kingdom. Otherwise, it's not possible to apply for indefinite leave to remain in the United Kingdom. You'd have to extend their visa in the United Kingdom. Now, contrast that with a situation where the child was born in the UK. Once they reach the age of 10, they're eligible to apply for British citizenship. So I hope that answers that question. Okay, let's look at the next question that's come in. Immigration law question. Let me read the question out. Assalamu alaikum. I applied last year for nationality and they refused. And they said I could apply after October 2021. That time is complete. I am reapplying. And the question is, do I need to do my fingerprints again? Okay, so do I need to do my fingerprints again when I'm doing my nationality application again after it's been refused? Understand that. Secondly, I was diagnosed with cancer. Sorry to hear that. Diagnosed with cancer and my treatment is currently in process. Does this affect my application because I have not been working for 2 years? Okay. Mashallah, very clear, straight to the point question. First question is that the initial or the first nationality application was refused in October 2021. Now, refused before, and you were told that you can apply in October 2021. If you apply now, do you have to do your biometrics again? Now, with each application that you submit, the general requirement is that you will need to enroll your biometrics. So you will have to go for your fingerprints and you will have to go for your photo to be taken. And that's certainly the case with all nationality applications. Now, what the Home Office has done, and I think this currently only applies to immigration applications, what the Home Office has done is they've started saying you can reuse your biometrics. So they're saying, look, if you've recently made an application, then you could be asked, instead of going to have your fingerprints taken, you could be asked to use what's known as the IDV app to upload your picture. So I think that's going to be the future plan for the Home Office, that in a lot of cases, you won't need to go to have your fingerprints and your photo taken, your biometrics enrolled. If there have been recent applications, then you will be asked to use an app to upload your data. Now, okay, that's all well and good. At the moment, from my experience, as far as nationality applications are concerned, all nationality applicants are being asked to have their fingerprints and photographs taken, to have their biometrics enrolled. As far as I'm aware, there's no change there. The second part of your question was in relation to the fact that you have been unwell recently and you've not been in employment for the last 2 years, and you're concerned about whether that has a negative impact on your application. Good news on that front, it has no bearing whatsoever on your nationality application. No bearing at all on your nationality application. And the reason I say that is that there's no requirement to show that you have been employed in the past or you continue to be employed now. There's no requirement in terms of finances. There's no requirement in terms of showing employment or self-employment when you apply for nationality. Those are requirements which you may have fulfilled when you applied for your previous visa extensions or you applied for indefinite leave to remain, but they do not apply when you apply for nationality in the United Kingdom. Now, what causes a certain amount of confusion is that when you complete the nationality application form, the online form or even the paper form, when you get to the end, there's a reference to submitting evidence of employment or previous employment, such as P60s and wage slips. Yeah, if you're working, yeah, or if you have worked in the past, if you're working or if you've worked in the past, then submit that evidence. Submit the current wage slips, submit the old P60s. However, that doesn't mean you need to be working now. If you're not working now, you don't need to submit recent wage slips. And if you've never worked, you don't need to submit any old P60s. A lot of the times we find that if you say to clients, look, you've been here for the last 5-6 years, do you have your old P60s? I know you've been working. A lot of the times they say, well, I can't find it. And the reality is that if you don't submit those documents and only submit the few documents that you have in terms of employment or self-employment, the Home Office does not refuse your application based on that. So the starting point is there is no requirement to be working. It doesn't matter that you've been not able to work due to your health for the last 2 years. And there's no requirement that you must have worked for the majority of time or for any time during the last 5 or 10 years. So don't worry about the employment, income, self-employment aspects of the application. Very misleading. They seem to suggest that there is some kind of requirement there. And certainly, as I've said, when you come to an end, the end of the form, there seems to be a request for documentation in relation to employment. But remember this, that's only if you're working or if you were previously employed. So look, there's nothing to worry about on that aspect of your application. Now, in terms of biometrics, yes, you do need to have your biometrics enrolled again. But mashallah, don't worry. Look, you've been told you can apply in October 2021 for nationality. So do get your application in. From the sounds of it, there's nothing to worry about. I'm sure all the other requirements have been fulfilled. Unfortunately, that brings us to the end of the show. Inshallah, we'll be back in the next couple of weeks. See you then. Assalamu alaikum.